Hi there. Welcome to Help Solve the Case. My name's Christine Burke, and we are currently in the middle of the Tyler Robinson Charlie Kirk trial process, specifically the preliminary hearings. And we had several days of testimony, which I covered here on the channel if you want to take a look at that. And we've also had two briefs filed, one from the state, which I went over earlier, and one from the defense, which we received very late last night. And as I promised, I wanted to compare both of them side by side because they each seemed to make some good arguments. Now, I'm not an attorney, but I do love the court process. And my goal here is to explore all sides of the issue and learn so that we can better our criminal justice system. Thank you for being here. And I already this morning put my assistant to work. Let's see what we've got here. Get myself in the right position. You can see here, folks always ask me what my prompt is. We've got comments. I'm biased this way, biased that way. I really try to do my best. Having an interest in all these things, I want to understand these court precedents and how they apply. And here's what I put, you can see the defense memo and the state memo. The defense memo just came out late last night, and I went through that. There's actually two videos, and that is in the pending trial playlist. All right, here's what I told Chatty. Chatty, we've been following the Tyler Robinson Charlie Kirk case. We saw the first part of the preliminary hearing, and both sides have now filed their briefs in anticipation of the hearing on September 1st, 2026. Would you be able to analyze from a neutral position which side, if any, did the best job in interpreting the law? And two, advise if he will be bound over, in your opinion, or not, and for what charges. Here's what we have. It only took him 1:04. He says, yes, after comparing both briefs against the bind over standard, and I haven't read this, I don't know what he's going to say. My view, that's Chatty's view, don't get on me, this is Chatty's view. My view is that the state is likely to win the bind over hearing overall, but the defense has identified two genuinely vulnerable areas. The capital, quote, great risk of death aggravator was that KGRD and count 7 child presence theory. I would not characterize this as a situation where the defense brief is weak. In fact, on the capital aggravator, I think the defense brief is the more intellectually rigorous one. The problem for Robinson is the procedural posture. Let's see. Utah Rule 7B says that if the magistrate finds probable cause that the charged crime was committed and the defendant committed it, the court must bind the defendant over. It also expressly allows the probable cause finding to rest in whole or part on reliable hearsay. Rule 1102 likewise expressly makes, quote, reliable hearsay admissible at Utah criminal preliminary examinations. That makes the defense's global argument that the entire case should fail because of the state's reliance on hearsay a very difficult argument for Judge Graff to accept at this stage, even though the defense has preserved its constitutional attack on those rules. The defense expressly argues that the hearsay regime violates constitutional and separation of powers principles and therefore asks for no bind over on any charge. He's giving us a little graph here. He says his bottom line, that's Chatty's, not mine, issue, hearsay, all charges, better legal argument, the state. He said his predicted ruling that the defense objection is preserved for the record, but the bind over will not be defeated. Count 1, capital aggravated murder. There you go, the KGRD. Better legal argument. Chatty rates it very close. Defense has the stronger narrowing argument. State has the stronger prelim argument. And we talked about the narrowing argument for the aggravated murder that the defense was kind of saying that the state was too broad, citing other states and different things. That was very interesting how both sides tried to apply that aggravating factor. And Chatty is leaning towards bind over, which means that the trial will continue as aggravated murder. Count 2, felony discharge. Chatty says the state clearly won and Tyler Robinson will be bound over. Counts 3 and 4, obstruction. He says the state clearly won and Robinson will be bound over. Count 5, deleting the text and witnesses, tampering, says the state clearly will bind over. Count 6, the quote, lawyer and stay silent, end quote, says the defense has a good substantive argument and the state is stronger at probable cause, and they will likely bind over. Count 7, the child under 14, defense. This is the count I think that has the best chance of being dismissed. Victim targeting, political expression enhancement, state at probable cause, though defense raises a legitimate causation issue. And Chatty says it likely will survive and get bound over in the charges. And the child presence enhancement to counts 1 and 2, the defense, if the court reaches the merits, and Chatty says he feels it's questionable, and the court may say it needn't decide it now. And there was some back and forth, if you've watched the videos, about how enhancements, and I want to try to explain this properly, sentencing enhancements are not a focus or requirement of the preliminary hearing. And they made some argument, the defense made some argument and said, no, they absolutely are. 1, who interpreted the law better? On the preliminary hearing standard, I give it to the state. Again, if you're just popping in, I'm telling you, this is Chatty. That matters enormously. The state correctly centers its entire brief on the proposition that this is not a guilt determination, probable cause versus beyond a reasonable doubt, my measuring cup. The prosecution says the threshold is merely a reasonable belief below preponderance with reasonable inferences drawn for the prosecution. A reasonable belief, just a reasonable a reasonable belief. That's hard to say. A reasonable belief below preponderance, which is 51%. The basic framing is reinforced by Rule 7b itself. Once probable cause exists, bind over is mandatory. And again, the focus has to be on probable cause. That standard, the measuring cup, you just need a little bit. You don't need to overflow the cup or fill the cup. The defense doesn't misunderstand that standard. Its better move is to argue that an inference can still cross the line into speculation. That's where their strongest arguments live. And I think that's important. They said they compared and contrasted between inference and speculation a lot in that document. I remember saying those over and over again. And the difference here is that the magistrate, the judge, has to make the inferences from the evidence presented whether there is probable cause as a reasonable belief. But he can't speculate. And how, it was kind of an ambiguous statement defining speculation versus inferring. And how easy, I think what Chatty's saying right here is how easy could it be to bleed over or actually dip your toe into speculation? And because we don't see the mental thought process, how are we going to know that? We don't know. The capital aggravator is the real fight. And why wouldn't it be? Because of the charge. What's going to end up, what could be the result with a guilty conviction on that element or the aggravator? Chatty says this is by far the most consequential question. The aggravating circumstance requires probable cause that Robinson knowingly created a great risk of death to someone other than Kirk and himself. The defense characterizes Utah law as requiring something approaching a high probability rather than merely some conceivable danger to another person. And I really thought it was interesting. As you read their briefs in isolation, you kind of read them, you go, okay, okay. And then you read the next one and you go, okay. And that's how the jury, with the presentation of both sides of the case, always an opportunity to change your mind. And the defense does a very good job demonstrating why the Utah cases are materially different from this shooting. It emphasizes that this was, and let me stop here, interrupt myself. They're talking about those cases that the state presented. The defense is saying, look, Utah is different than, I think they did a lot of Pennsylvania and stuff. They're saying, this is Utah. And the defense emphasizes that this was one shot from a scoped rifle at an identified target from a fixed rooftop position with the projectile hitting the intended target. Nobody else was struck, and without indiscriminate fire, multiple rounds, or ricochets. It also attacks the state's, quote, line of fire theory as largely imported from Pennsylvania rather than derived directly from Utah precedent. And Chatty says that's a serious argument. Where I think the defense goes a little too far, however, he says, is when it effectively converts the factual circumstances of Pierre, Johnson, and Sosa Hurtado into something resembling a mandatory checklist that Utah KGRD essentially requires multiple rounds, actual attacks upon others, injuries to others, or a concatenating series of dangerous events. I kind of took it that way when I was reading it. And it sounds like Chatty's saying, maybe no. He says those cases can certainly be read as demonstrating how narrowly Utah has historically applied KGRD, but examples of circumstances satisfying an aggravator are not necessarily exclusive prerequisites. Maybe he's saying you don't necessarily have the list. And that's where the state has its best response. Chatty says the state uses Sosa Hurtado's, which is the same case, quote, zone of danger language, and the factors involving the spatial relationship between the third person, the victim, and the shooter, which I believe the third person is the questioner, not sure, together with indirect dangers such as stray or ricocheting bullets. More importantly, the state identifies an actual person rather than relying solely on, quote, there were 3,000 people there. The questioner, according to the state, was a few feet in front of Kirk and directly between the firing position and Kirk, with others located behind the questioner. That fact may save the aggravator at preliminary hearing. The state adds that Robinson allegedly brought 4 rounds. His practice shot had not always hit the bullseye, and the rifle had been disassembled and reassembled before the shot. It argues that those circumstances permit the inference that Robinson knew a miss was possible. So it kind of sounds to me here that the defense is saying more of there had to be some action, that they needed all those 3 elements. There had to be some action, such as more than one bullet fired, more than one person in close proximity, and the actual intention, I'm going to get so-and-so and so-and-so and so-and-so, where the state, it's more possibility. Look, he brought 4 rounds. He wasn't a good shot. He knew he wasn't a good shot. And the scope could have been jacked up from being disassembled, reassembled. Do you understand that? That's an interesting distinction that the judge is going to have to potentially interpret and itemize for us when he makes his decision. And this is going to potentially provide precedent about how that is going to be interpreted. Possibility versus what I'm seeing as more active action. I don't know if that makes sense. Active, taking steps. The defense has a compelling factual response. The actual videos supposedly show substantial separation between the questioner and Kirk, with barriers, grass, table, and other space between them. Does using those cases, even though we don't have an itemized 1, 2, 3, according to Chatty, under, what is it, Sosa Hurtado, even though we don't have a 1, 2, 3 list in Utah, apparently, does the precedent, sometimes when the Supreme Court decisions and different things come down, they talk about a 2-part test, that it has to be this and this. Is this going to delineate a 1 or 2 or 3-part test, that it's going to have to be this possibility versus action, or possibility and action? We don't know. Chatty says, this is where I think September 1st is going to turn. Not, quote, was there a crowd? Not, quote, was a rifle dangerous? The meaningful question is, did the evidence actually place an identifiable third person inside the zone of lethal danger created by the shot? And is there a reasonable basis to infer Robinson knew that? That's an interesting position they're taking. I believe Chatty's referencing the questioner, not the crowd, not the knowing the rifle was dangerous, but it sounds more the proximity. And I think we saw when the defense in their pleading specifically referred to the scope. Remember, I went like this, and what he would have been able to see within the scope, if Chatty is right. Again, this is Chatty. If Judge Graff answers yes, count 1 survives. He says, my prediction on count 1, I would currently put it around 65-35 in favor of bind over on aggravated murder. He's given us a rating system here. But I'm considerably less confident about that than I am about the other felony counts. Were I evaluating this under a trial sufficiency standard, which is different than probable cause, reasonable doubt, my assessment would shift materially towards the defense. Let's talk about this. Put my measuring cup back in the patio, in my gardening kit. I'm going to get that because I think it's important. Hopefully that's a good visual for you guys. Oh, I forgot to put the water in it. Probable cause is down here. Proof beyond a reasonable doubt would be up to the brim or flowing over. Using my analogy, hopefully that's an effective, I'm holding it in front of my face so you can see it. Hopefully that's an effective analogy. But what I also pointed out is that once the case gets to the prosecutor, my issue that I see in both sides of the table, looking at from the prosecution perspective and the defense perspective, is that the prosecution gets the case at probable cause. It's not a slam dunk, potentially, at arrest, at charging. It's only probable cause. It's down here, which means, as I mentioned, the state has this entire gap that they have to raise the water level, raise the conviction bar or the evidence bar all the way to the top and make it overflowing. Hopefully that makes sense. Now, what happens is they've already investigated the case. When they're here, the water may be turned off. They may not be able to fill the case and overflow the cup with what they have, because evidence is evidence. If the water gets shut off and there's no more facts or no more evidence or no more witness testifying, there may be not enough. If you're cooking something, we're speaking of cooking, and you need 4 eggs and you only have 2, your recipe is not going to come out right. i.e., you may not be able to reach and secure a conviction on all the charges, because you may not be able to prove it enough. You don't have everything that you need. And that is many times a disadvantage that the prosecution faces because the arrest is made. And that's not a negative on anybody or whatever. This is also one consideration where I'm saying that this is potentially why we haven't seen everything. The prosecution is holding their cards at the preliminary hearing because they only have to be here. They don't have to be here yet. But in a case, sometimes there's only so much evidence. Why did we not see all the video? Why didn't we hear the people testifying in person? Why did we not see all this stuff? That may be the gap. That may overcome the distance. Probable cause versus beyond a reasonable doubt. And that's what Chat is saying right here. Under a trial sufficiency standard, it would shift towards the defense. And he says the defense has shown a genuine doctrinal problem with stretching, quote, great risk into firing any rifle toward a place where another human happens to be somewhere near the trajectory. Because if that were enough, Chatty says, the aggravator could swallow a substantial category of intentional firearm murders committed in populated places. And I agree with that. I talked about, as a police officer, how many rounds I carry. We get trained about overkill, overshooting, stray rounds and things. The narrowing concern is exactly why the defense spends so much time on the constitutional requirement to construe death eligibility aggravators narrowly. Its brief says Utah precedent requires more than mere presence and a mere possibility of harm. Something to think about when Utah added that or enacted that portion of that aggravator. Was it a drive-by shooting enhancement to help prosecute drive-by shooting or to dissuade drive-by shootings, in that a random spray of bullets, for example, indiscriminately can kill other people without intent? They just wanted to put bullet holes up the house, or shoot out the windows of a car, or shoot out the windows of the house, but they actually killed somebody. Was the enhancement for that, or was it just to include anybody and everybody? We don't know. We would have to go back and look at the legislative discussions around what their intent was for using this aggravated factor. And that may necessitate, I don't know if it's possible, elaborating more specific things here. It's an interesting point here, how it's going to be interpreted and what the use is for. Chatty says the defense wins the sophisticated legal debate and the state probably wins the preliminary hearing application. What he's saying here is that, yeah, the state's going to win because he feels it met the probable cause, but the greater issue facing Utah and us and everything, this is where we learn from these cases. Are they going to have to do something with the legislation? Was the intent of the legislation is it being, or will it be applied properly? That's what he's saying there. He said that's an important distinction. Count 2, the firearm discharge. He sees virtually no realistic bind-over issue here if the admitted evidence remains in the case. The statute as presented by the state requires discharge of a firearm towards an individual, knowing or having reason to believe someone may be endangered, resulting in serious bodily injury. The state's evidence is that a rifle was intentionally fired at Kirk and killed him. We know that. He says, bind over, very high confidence. Counts 3 and 4, obstruction. He says, same result. The state's theory is concealment, removal of the rifle, and concealment, removal of the clothing with intent to hinder the investigation. It points not only to recovery of the rifle in the wooded area, but to Robinson's alleged communications about leaving the rifle in a bush and wanting to retrieve it without leaving evidence. He says, at probable cause, that's plenty. Bind over. Count 5, telling Twiggs to delete the exchange. He says this is also quite strong for the state. The alleged communication is extraordinarily direct. Quote, delete this exchange. The state ties it to an ongoing discussion about the shooting, police activity, the hidden rifle, and leaving no evidence. Chatty says that isn't a difficult probable cause inference. Bind over. Count 6, ask for a lawyer and stay silent. He says this one is considerably more interesting. He says the defense's framing is good. The complete communication allegedly includes ask for a lawyer and stay silent, ... Make sure the police follow the right procedures, proper warrants and stuff. Be polite and respectful. And the defense characterizes this as advice to Twiggs to exercise constitutional rights rather than an effort to obstruct an investigation. And that is a good point. Fifth Amendment right to self-incrimination, things like that. I don't know. To me, the polite and respectful and all that, there's nothing in there that I recall about, I don't know. I could use some verbiage and against the police and things like that. We don't see that there. So this will be interesting. If you isolate that sentence, Chatty, strongly prefers the defense's interpretation. Quote, you should get an attorney and don't answer police questions, end quote, is ordinarily legitimate advice. But Judge Graff won't have to isolate it. It means that sentence won't have to be taken by itself. The state puts it in the context of the preceding communications, allegations about keeping the crime secret, retrieving the rifle unseen, leaving no evidence, knowing police were investigating, directing deletion of the conversation, and then saying don't speak with the police. The state, according to Chatty, that was the final piece of the obstruction puzzle, if you will. At trial, the state may face a much harder mens rea question, meaning intent. At probable cause, I think that context gets count 6 over the line. Again, he's saying probable cause, not the full cup. You guys are gonna see. We're gonna be talking about the measuring cup going forward. How does the case measure up? All right. Prediction bind over 70-30. Count 7, child under 14. Here, I think the defense has its best chance of actually winning something on September 1st. The statute isn't satisfied merely because children happen to be present. As both briefs describe it, the state must establish knowledge that a child under 14 was present and may see or hear the violent offense. The state proves actual presence fairly well. Video allegedly shows at least one child under 14 and women holding infants. But presence isn't the difficult element, according to Chatty. Knowledge is. That means Tyler would have had to have that knowledge. The state's argument essentially becomes Robinson had been around the campus, families and children were attending, he had a rooftop view, he could see the crowd, therefore it's reasonable to infer, there's that word, he knew children under 14 were there. The defense identifies the weakness very effectively. The shooter was roughly 400 feet away, was in the final firing position for only about 35 to 44 seconds, and there was allegedly no evidence demonstrating that he actually saw a child, passed an identifiable child beforehand, or otherwise knew a person under 14 was present. That's not merely competing evidence. That's a legitimate, here we go, inference versus speculation question. We talked about that earlier, about how that can bleed over and what that really means. There's a good example. Here's a good example of what inferring versus speculating means. And, quote, there are probably children somewhere in a crowd of thousands isn't necessarily the same thing as this defendant knew a child younger than 14 was physically present and might see or hear the offense. Chatty leans defense there. He predicts count 7 is the most likely charge to be refused on bind over. He'd put it 55-45 defense. The low probable cause threshold makes him reluctant to go higher than that. 7. Political expression victim targeting enhancement. He says, I initially thought this argument was weaker for the state than I do after reading the entire briefing. The defense, let me see what he says. I initially thought this argument was weaker for the state than I do after reading the entire briefing. The defense has a fair point. Quote, I had enough of his hatred doesn't identify which expression, belief, or personal attribute caused Kirk to be selected. The defense argues that the state substitutes assumptions about Robinson's relationship with Twiggs for proof of Robinson's motive. He says, if that were all the state had, I might agree, but it isn't. The state also points to an engraved cartridge stating, quote, hey, fascist, catch, along with the context of Kirk's political activities and Robinson's alleged statements that Kirk's, quote, hatred motivated him. At probable cause, quote, hey, fascist, catch is pretty difficult for the defense to explain away as having no bearing whatsoever on political motivation. The state does not have to establish beyond a reasonable doubt precisely which Kirk statement motivated Robinson. That's an interesting point. It needs a reasonable inference that Kirk was intentionally selected because of Robinson's belief or perception regarding Kirk's political expression. And Chatty says he thinks the state gets there. So he thinks that the victim targeting survives. All right. So what do I think Judge Graff actually does? That's Chatty. His prediction today is count 1, the aggravated murder is bound over. Count 2, the felony discharge. Count 3, the obstruction firearm. Count 4, the obstruction clothing. Count 5, the witness tampering and the deleting the text. Count 6, witness tampering. Don't speak to the police. He feels that those will be bound over, and he's not sure. He says it's a toss-up, a true toss-up, he says. On count 7, the violent offense in the presence of a child. Again, remember, we're here. They have to only be here. They don't have to be here yet. At trial, they have to be here. Prelim here. He says it likely survives the victim targeting political expression enhancement. He says, for the sentencing enhancements to attach to counts 1 and 2, the state separately argues the magistrate does not have to make a bind-over determination because those enhancements do not alter the offense classification. The defense responds with apprendi, that was the case, and argues punishment-increasing facts must receive a probable cause determination. That may allow Judge Graff to sidestep part of that fight rather than decide it now. And he says, if you force me to choose who won the briefs, the state 6 out of 10, the defense 8 out of 10, but the state is more likely to win the hearings. It sounds like he likes the defense's brief better, but the state is more likely to win. And he says that isn't contradictory. The defense brief does considerably more actual appellate-style doctrinal work, especially on KGRD. I agree. It was very legalese. It attacks the state's proposed rule, traces why capital aggravators have to be narrow, compares the Utah fact pattern, and asks the court where the limiting principle would be. The state seemed to rely more on evidence, if I can say that, and the defense seemed to rely more on interpretation. Chatty continues. He says the state's brief is simpler because it can afford to be simpler. Here's evidence. Here's reasonable inference. Probable cause is a low bar, therefore bind over. At a preliminary hearing, that is an extremely powerful position. The one thing I would not say in a video is that, quote, the defense proved the death penalty is off the table, end quote. They did not. What I would say is, quote, the defense found the pressure point in the state's death penalty case. Now the question is whether probable cause is low enough to carry the aggravator across it, end quote. That to me is the story of September 1st. Chatty, you're not saying that they proved it regarding the death penalty, but they're going for that, right? They're trying for that. And they found the pressure point. And with only a probable cause determination, is that going to be a bar that they can overcome it in the preliminary hearing stage? I don't know what you would think. There you go. Here's the whole AI's evaluation. We look forward to the September 1st hearing. Thank you for being here. And of course, I will see you on the next case and on the next video. Thank you for your support of the channel.